is Heather, and this is another Delphi update. So, we're reading the court documents that drop. In this case, in this last week, we've had many, including the defense's second motion to disqualify the judge, which is a long one. So, get ready for that one. I got it recorded still, so it's gonna be a long one. But there, besides that, we also got a bunch of motions for continuance from the defense. I read through a bunch of those. Motion to vacate the safekeeping order, and also a petition for public funds. So we read through those in my last update, and this is going to be we're going to read through the state's response to the defense's fourth motion for Frank's hearing, and also the motion to dismiss the motion to suppress. So the defense filed a motion to suppress statements made from Richard Allen that might be construed as a confession or something along those lines because of the conditions he was under. He may have said them under duress for all sorts of reasons. They probably shouldn't be admissible. Uh, and they want a hearing on that. And of course, the state wants to object to dismissing the motion. So we'll get to that in just a second. Let's first read through the state's response to the defense's fourth motion for Frank's hearing. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and files its response to Richard Allen's fourth. I swear, every time I start recording, my dog is like, okay, let me lay down now. Please, dog. Such a butt. All right. She's cute butt, though. All right. Sorry. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and files its response to Richard Allen's fourth Frank's motion based on newly discovered evidence and request for hearing referred to by the state as the defense's fourth motion for Frank's hearing. That, as the previous three Frank's motions filed by the defense, this fourth motion illustrates a complete misunderstanding of the rulings in Franks versus Delaware. Okay, so now Nick McClelland is going to give you a lesson on the law here, I guess, on how to apply Franks. All right, so, and the purpose of a Frank's challenge to a search warrant. So the defense makes the same allegations in this motion as it has in its previous three motions that Sheriff Tony Liggett failed to advise the judge of material facts, and that without these omissions, the search warrant would not have been issued. The defense consistently in the three previous Frank's motions have misstated and mischaracterized facts surrounding this case. That trend continues in this most recent Frank's motion. The defense motion, I apologize for the blurriness. These are pictures taken of, screenshots taken of pictures that other people posted on social media, and same with why these little spots are like these black spots are there, because I got it off of Reddit, uh, pictures on Reddit. All right, so defense motion in paragraph 25 consists of lists A through, I think that's an L, of information that the defense asserts should not have been omitted from the probable cause affidavit for the search warrant. However, the offense, or sorry, hold on. I'm trying to think and read at the same time, and it's not good. Uh, can't do two things. However, the information is either irrelevant for probable cause purposes or wholly inaccurate. The state has addressed most of these inaccurate facts in previous replies to Frank's motions. The new topic that the defense focuses on in the fourth Franks motion is the AT&T pings. He quote unquote pings. What? They are pings. Why is he saying that they're, or implying that they're not? The defense includes in this motion information about pings generated by AT&T on February 13th, 2017 through February 14th, 2017. The day they went missing, the girls went missing to the day that they were found. The defense also includes segments made by Sergeant Blocher when he was consulted by Steve Mullins about the pings. The information in the motion show that the defense does not understand the information contained in the pings and then exacerbates the problem by mischaracterizing the statements made by Sergeant Blocher. Further, contrary to what the defense motion states, the defense have known about the pings well before uh, well before April 26, 2024 discovery disclosure. So he's claiming that the defense knew about these pings, but did they? I don't know if they did or not. But even if they did, I don't think they did because they didn't know that there were other phones in the premises. So when AT&T pings a phone, they will send a signal from the tower nearest the cellular device to the cellular device. From the time it takes the signal to reach the device and get back to the tower, they will determine a location of that device. The location can be accurate at times, but can be completely inaccurate at times. Well, then, how can you use that data ever? What do you mean it's accurate sometimes and not accurate other times? The location can be, accurate and inaccurate. Okay, so if the tower cannot make cellular contact with the device when the ping data will show a historical data location, that means the service provider will show a location from the historical data collected from the device. So it's saying that it pinged their, like in the past. It doesn't even make sense. That means the service provider will show a location from the historical data collected from the device. It is the last longitude and latitude collected from the tower when it had good service with the device. That is not a pinpoint location. Well, no one's saying that that it is necessarily a pinpoint location, but we do have geofence location pointing to 3 phones that were in the area that are not the victims and are not Richard Allen's or connected to him in any way. So, to fit the state's theory as to when the girls were, when their lives were taken, which is they think on that in that afternoon of the 13th, and then they just weren't found until the 14th, but there were searches all over the premises, so that makes no sense anyways. You see how things just don't add up? There were searches all over the place, but no one found the girls until the next morning. It just, none of it adds up. And these 3 pings that Nick McClelland is saying, that data is only accurate some of the times, but not all of the time. So it only is accurate when they want it to be accurate, apparently. That means the service provider will show a location from the historical data collected from the device. It is the last longitude and latitude collected from the tower when it had good service. That is not a pinpoint location. The location given comes with an inaccuracy range anywhere from 400 meters to 25,000 meters. Okay, that's a little insane, and I don't think that that could be possible. That's a huge difference. Those inaccuracy ranges can differ based on several factors. A tower can lose contact with the device because the device runs out of power or because the device loses cellular service, Law enforcement use this as a tool in certain cases to attempt to locate a cellular device. It is not always an accurate way to locate a device, but can be used as a tool to help determine the location of the device. Exactly. It's not necessarily giving you an accurate pinpoint location of these phones, but it's giving you a helpful uh, place to determine where the location of the phones were at that time in that vicinity. So, regardless of if it was pinpoint on the money where the geofence locating or geofence data is telling us, even if it's 400, 500, 600 meters from there, at least we still know that there was like other activity in that area that was never reported on, or no one ever suspected people in that area, like no, or talked to anybody with those geofence. Why didn't law enforcement talk to those people? Because they should have had those numbers, right? I don't know. It just all seems really shady to me. All right, so moving on. In our current case, when the girls went missing, law enforcement contacted AT&T and asked AT&T to ping the cell phone of Liberty German. This was done in an effort to locate the girls. The pings came in from AT&T every 15 minutes. That means that AT&T would send an email to law enforcement every 15 minutes showing the ping results of pinging Liberty German's phone. Each ping will give a latitude and longitude of the device with a radius estimate and the source of that data. The location data is not a pinpoint location but can range in accuracy based on the radius estimate and or based on the contact that the phone had with the tower. So why can't it still be used as a helpful tool to find out who was in that area? Just because it doesn't give you a pinpoint accuracy, that doesn't mean that it can't be helpful to find out who was in that area that day. And I think that's what the defense is looking to achieve there. Nick McClelland, as you're sitting here saying, can't be done. It's not accurate, but if it was something to pinpoint Richard Allen in that area, you could better believe that they would believe that it was accurate data. Cops, and prosecutors, they don't want certain information when it doesn't fit their case. They can shoo it away. So the location data is not a pinpoint location. If the phone did not have contact with the tower, the latitude and longitude is based on historical data. In those cases, there will not be an inaccuracy range because the location is based on historical data and not live data. Okay, well, that makes sense, but maybe. But tell us, I need to know more about that. And I'm not just going to take Nick McClelland's word for this. The defense proposed Indiana State Police Sergeant Greg Edwards on February 27th. The defense presented the AT&T pings to Sergeant Edwards for his review. Sergeant Edwards explained the data in the pings to the defense at that time. Sergeant Edwards stated, "So those emails begin coming in and you've got this text block that has to do with, again, the case ID or the number that they've assigned to it. AT&T has assigned to it. You've got the mobile number, so the phone number that is assigned to that device that they're currently pinging, and we can see the last four digits here are 7599. Confidence level, they might put in whether or not that was the high confidence location for it, meaning that they had a lot of good information coming in from the device and from the tower network. This sounds like a lot of word salad to say it's real close within the area. This is a quote. Sergeant Edwards is stating this. Okay, this is all Sergeant Edwards. We're quoting him. And I honestly feel like he is just BSing as he's going, as he's making it up as it goes along. It might say that it's a low confidence area, meaning that it's quite large, or here they aren't even listing the confidence area, so I don't know what to say about the confidence area. Sometimes the confidence level, they'll have a size in meters. So say that this is within 1,000 meters, we believe that the device is somewhere within 1,000 meters of this geolocation. So that's what they'll list in the in the confidence area. Then the latitude and longitude. So they give you a latitude and longitude coordinate so you can plot that on a map. And then radius, location accuracy unknown. So they didn't give us, that's why there's no confidence level. There's no number of meters from that geopoint that associated with it. And why? Explain that again? He just said a bunch of stuff without saying a bunch of stuff. Let me read that again. So that's why they'll So that's what they'll list in the confidence area. Then the latitude and the longitude. So they give you a latitude and longitude coordinate so you can plot that on a map. And then radius, location accuracy unknown. So they didn't give us. That's why there's no confidence level. There's no number of meters from the geopoint that's associated with it. A bunch of word salad, in my opinion. Trying to explain something and not knowing how to do it. You're all over the place. And then data source is telling us that that's coming from historical records. That's not coming from the device like live and active. They're providing information that's coming from. They're going back and they're collecting information from the historical call detail records. Sergeant Edwards later says, with AT&T, part of the reason why it says historical here is that if they say, all right, we're going to ping that phone, but they can't get to the phone, well then they'll use the last known location from the historical records. So that is different than the live ping. It's going back to the historical. So this whole thing is just quoting an officer who I don't trust for a second, knows perfectly. He's not an expert in phones. And if he is, they didn't state that. He's a sergeant investigating this case. I want someone who has extreme amounts of wealth of knowledge of for cell phone cell phones and how they ping, and an expert in phone forensics, cell phone forensics, not Sergeant Edwards at the local precinct who maybe took a class or two on how to find a pinged phone or something. You know what I'm saying? You need an expert to argue this. And this whole motion or response, I should say, to this request for the Frank's motion is, well, not the whole motion, but you have to admit a large chunk of it is Sergeant Edwards' statement. Statements from someone who's not an expert in cell phones, and we're going to take this as word. Okay. All right, so Sergeant Edwards also says a whole bunch of other stuff. So that is different than the live ping. It's going back to the historical record saying we can't find the phone right now, but here's what we know, where we know it was last. So the ping emails collected all show historical data, according to Nick McClelland. That means the tower could not find the phone at the moment the ping was initiated, so it just gave the service provider the historical data location. I also think that the girls weren't there at this time. I don't believe in the state's timeline or theory. I think the girls were taken and brought somewhere to basically hold them for a few hours until the rest of the clan got there and did what they were going to do to the girls. And then they moved the bodies to where they were found because that was not the crime scene. Because Libby's BLOOD was never found to be anywhere in that vicinity. She was like she was drained of that liquid, and it was not found anywhere where she was, and she was on the ground. So it was obviously not, she wasn't in the place where she lost her life. So not the crime scene. All right. So the ping emails collected all show historical data. That means that the tower could not find the phone at the moment that the ping was initiated, so it just gave the service provider the historical data location. That doesn't mean that the phone wasn't in the area or that the phone wasn't in working condition. It means that the tower could not contact the phone. That historical data continues through all the pings. Sergeant Edwards, more with Sergeant Edwards, who is not an expert. He did his best to explain to the defense. Oh, he did his best, but those poor defense folks, they just could not understand. That's how he's that's how he's saying that. Like Sergeant Edwards did his best, but those defense attorneys, they just are too dumb to get it. That's what he's saying. He attempted to explain to them how pings work, what the longitude and latitude data means, and what historical location means. The defense still does not understand how to interpret the pings from AT&T. The pings from AT&T show the location of the phone through historical data. That means that the tower is not contacting the phone. The defense then goes on to mischaracterize Sergeant Blocher's statements contained in Steve Mullen's report. Sergeant Blocher reports that from his evaluation, the last contact that the phone had with the cellular tower was at 5:44 p.m. on February 13th, 2017. The records from AT&T show that there has been no contact with the tower since then. So maybe the phone died at that time? Is that what they're saying? Or were the girls taken and moved somewhere else? I don't know. And the phone was taken from them. From that information, he determined that the phone was no longer in the area or no longer in working condition. The defense wants this to mean that the phone is not in the area from the evening of February 13th until the morning of February 14th. This is not what that means. Well, I think it could mean that, and I could be a juror, so it means that since the pings were only showing the historical data location, the phone was not having contact with the tower. Sergeant Blocher explained that could be because the phone was not in the area, but it could also mean that the phone was not working. This is consistent with the pings collected from February 13th through the 14th, that the pings are giving the estimated longitude and latitude based on historical data location information, not live pings. This information is consistent with the information in the probable cause. The information that we have is that the girls were dropped off at the trails around 1:30 on February 13th, and that at 2:13 p.m. their kidnapper ordered them down the hill. There is no evidence that the girls were ever taken from the area. I think their phone not yeah, I think there could be evidence that they were taken from the area, but you're not looking because you don't want to find it. Or that they were brought back to the area later to have their lives taken, but clearly the crime scene was somewhere else because the drained fluid from Libby was not at the crime scene. So they were moved. So this infuriates me. All right. So every indication is that they were ordered down the hill and then their lives were taken soon after that. The historical location data from the AT&T pings does not mean that the phone was not in the area during the evening of February 13th until the morning of February 14th. It is another example of the defense taking information and stating that it means something that it doesn't. him saying that, Nick McLeland saying this, makes me all the more convinced that the defense are right. This is consistent throughout all of their Frank's motions. Okay. The state has outlined the test used in Frank's in its prior responses in order to have a Frank's hearing. The defense's attack on probable cause must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an officer or an offer of proof. The claim should point out specifically the portion of the warrant affidavit that is claimed to be false and should be accompanied by affidavits or sworn affidavits or reliable statements of witnesses. They have told you already how many times they used false information to get the search warrant to Richard Allen's home. Can you guys lay down, please? You're all tip-tapping toeing and it's annoying. Well, lay down, please. All right. Good boy, Dexter. All right, so the defense must show that they're wait. Yeah, okay. So I was just making sure that I didn't skip a sentence. The defense must show that there is inaccurate or omitted information and that probable cause is lacking if the omitted information is included. Franks versus Delaware. Herein, the defense claims omissions, if included, would negate probable cause for the search warrant of Richard Allen's residence. Defense has not met its burden. The omitted, yeah, I think so many attorneys and YouTubers and citizens of this country and other countries are looking at the probable cause affidavit going, so why did they pick Richard Allen? And we still don't really know. All right, so the defense has not met its burden. According to Nick McLeland, the omitted information from the AT&T pings does not negate the fact that Richard Allen places himself on the bridge at the same time that Liberty German took the video of Bridge Guy, who ordered the girls down the hill. That doesn't mean that he was there at the precise moment. He said he was there between the hours of 1:30 and 3:30. That doesn't mean that he was in the precise area. So I like how the prosecution twists words. Further, Richard Allen admits that he was wearing clothing matching the clothing that Bridge Guy was wearing that day. That, along with other eyewitness testimony and the other evidence gathered, establishes probable cause that Richard Allen is Bridge Guy and he is the one who took the girls. I don't think so, but whatever. Wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and files their response to the defendant's fourth motion for a Frank's hearing and would ask the court to find that the defense has not met its burden to warrant a Frank's hearing. The motion contains nothing more than their beliefs about what the AT&T pings mean without an understanding of what the data means. Sheriff Tony Liggett did not intentionally or recklessly omit evidence or lie about evidence in the probable cause affidavit to support the search warrant in an effort to mislead the judge. And I beg to differ, and I believe that the other Frank's motions have proven that false. So, not too bad. I'm not the judge. All right, so the facts in the affidavit are true and accurate and are supported by evidence collected in the case. Sheriff Tony Liggett relied on that evidence when drafting the affidavit for the search warrant as the best reliable information known to him and related to Richard Allen at the time of the request. That there are no inaccuracies or omissions in the probable cause, seriously, for the search warrant that are of a material nature, and that the defense argument and law enforcement dishonestly is pervasive and relates back to the affidavit in question is not supported by sworn statements, affidavits, or other reliable statements. So there you go. I'm not even going to talk about that because it's just going to make me annoyed. Talking about Nick McLeland stating that there were no inaccuracies or omissions in the probable cause that would are any material nature to the defendant, I beg to differ. But let's move on. All right, so this is the motion to dismiss the motion to suppress his statements that could be considered confessions. All right, so now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and requests the court to dismiss the defendant's motion to suppress filed April 11th, 2024, in that it is too vague in violation of Criminal Rule of Procedure 2.7b and in support of said motion states the following. Number one, that the defense filed a motion to suppress on April 11th, asking the court to suppress the statements the defendant has made while he has been incarcerated in the Department of Corrections. Number two, that the defense seems to imply that there are statements made by the defendant while he was incarcerated that were coerced by state actors during a custodial interrogation. Number three, that the defense fails to put the state on notice which state actors coerce the defendant, fails to outline which statements they are seeking to suppress, fails to state how the defendant was coerced in a custodial interrogation setting, and fails to outline the basis for their motion. I thought they were pretty clear, but okay. Number four, that under Criminal Rules of Procedure 2.7b, when the defendant files a motion to suppress, the defendant must clearly state the items or statements to be suppressed and the basis for the suppression. He just wants them to say it out loud so that it's in the court of public opinion then. Number five, that the state contacted the defense and requested that they fix the deficiencies in their motion, but the defense refuses to give the state any guidance on their motion to suppress and refuses to comply with Criminal Rule 2.7b. Baloney. Number six, that the defense has failed to outline which statements they wish to be suppressed, all of them, who the state actors are that coerce the statements, and the basis for the suppression. The guards that were there watching him, and just because I can't give you a name doesn't mean that it didn't happen. And I'm sure that the defense team did do their due diligence and investigate who the guards were that were watching Richard Allen at any time to determine who might have these odious ties and who might have been the ones coercing his confessions. But anyways, Nick McLeland says you should deny their order for all those reasons and blah. I don't even care because it's coming from Nick. So I'm not going to give him any more time. I wanted to, there were so many filings, I have to break them up in a certain way that makes sense. And these were coming from the state, and we've got others coming from the defense. And so it's just how it goes. So unfortunately, you had to hear all the state motions that came in this week. So luckily, this is all of them. So that's the good news. And we can move on to some more interesting ones yet to come. I'm going to be going over the defense's second motion to disqualify Judge Gall, and also there's going to be some ex parte communications to Judge Gall about maybe the way she's handling herself in these proceedings. So stay tuned for that. Make sure that you have the notification bell on, that you're subscribed, and please be sure to hit the like button on your way out. And I look forward to seeing you in the next one. Thanks, guys. Take care. Have a good one. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.